Hello, I'm Jeremy Morton. Welcome to this webinar on the subject of non-disclosure agreements in IP deals, best practice for negotiation and drafting, or perhaps that should be drafting and negotiation. Let's have a look at the agenda for today. We'll be looking at when to use NDAs and why, the position in the absence of an NDA. We'll look at some actual drafting, step by step, and also some practicalities. Well, there are many examples of successful claims in the courts that were not based on written formal confidentiality terms. There's a very useful summary in the 2016 case of Kerry against Bakkavor. There, the defendants misused product information that had been disclosed for purely regulatory purposes relating to edible infused oils. So the supplier of those had to supply some information as well to meet regulatory requirements. And then the defendants went off and developed their own product based on that information. There weren't any express confidentiality terms. It fell squarely within Coker and Clark principles, and the claimants were granted a springboard injunction lasting as long as it would have taken the defendants to develop the product formulae from public information and reverse engineering legitimately, which was a 1-year period of injunctive relief. Now, many other authorities are concerned with the position when employees are in possession of confidential information and what they do with that after they leave employment. And there are special rules about that, which we don't need to concern ourselves with today. It's worth noting that those kinds of restrictions were in fact applied to a relationship with a consultant in this Vestergaard, Fransen and Bestnet case, which is a very useful authority generally in this area of law. Consultant had worked on the claimant's product development and then used it as a starting point in working for a rival.